Welcome, everybody. My name is Bob Brocker. I'm the board president of AgeWise Colorado, joined today by Barbara Boyer, who's our executive director. And want to start with just a little commercial for AgeWise, and then I'll introduce our panelists for today, and we'll get rolling. So I always like to show this because a lot of what we're doing is talking to folks that are sort of in this middle area right here. You got kids, you're working, and one day something happens over here on this side and you have to engage. And where do you go to do that? And for most people, the typical answer is you go to Google and you start poking. See what you can find. And we don't feel like that's the best solution, which is why we created this organization. So if you're an adult child of aging parents, or an older adult yourself, or you're a Coloradan over the age of 40, we're here to help you navigate the aging journey and to help you make powerful and knowledgeable choices to know, to reduce stress and confusion. So think of us as that kind of warm blanket, that friendly helping hand that you seek. And so we can ease your mind with a free hub of reliable, easy to access information and vetted service providers. So we provide access to valuable education sessions like this one we're having today that help make you wiser and better informed. For you employers out there, now we're actually providing what we would call a soft employee benefit for those inevitable times when one of your own faces a stress-filled situation with an aging loved one, or a landing spot, a resource, a place to ease their stress and worry and reduce those frenzied and unplanned absences from work and making your organization a better place to be. I saw something recently, something like 32%. I don't know where this study came from, but 32% of people are either have quit or planning to quit to be a caregiver. So that's a pretty big number. So on this hub of all these different aging related resources and information that we provide, we're talking today about these two in yellow. And now I'm going to introduce our two panelists for today, starting with Louis Osterman. Louis provides modern estate planning solutions for families, business owners, and individuals who want to protect themselves and their loved ones. After graduating with honors from Boston University School of Law, Louis decided to return home to Colorado and to establish his legal practice. Drawing from his experience as a litigator, Louis strives to assist clients with recognizing and solving costly and time-consuming problems before they arise. Prides himself on building outstanding client relationships that directly lead to well-designed plans that fit clients' lives, not the other way around. Louis received his bachelor's degree from the University of Colorado Boulder and his law degree from Boston University School of Law. When not in the office, you can find Louis riding his bike, snowboarding, working on his house, and exploring Denver's very large art scene. And then
Thank you.
You're very welcome. And next, Justin Kellewald. Justin is a financial advisor with Edward Jones in Denver. He's originally from Michigan, moved to Colorado, to God's country in 2015. Graduated with a bachelor's degree in biomedical engineering, of all things, before transitioning careers to Edward Jones. Justin has been with Edward Jones since 2018, enjoys working to find solutions to life's problems with his clients. Justin works directly with individuals and families during retirement or living in retirement. Although each case is unique, this typically involves finding the best strategies for creating a retirement paycheck, ensuring you're fulfilling your purpose in retirement, and making sure an estate plan is set up for you and your family. Justin is happy to have a conversation with anyone who fits in this demographic. And like Louis, Justin enjoys outdoors, snowboarding and mountain biking, camping and hiking. And you can often find Lewis Justin, I'm sorry, just playing his guitar and strumming away, staying active at the gym. So thank you so much, gentlemen, for joining us today and for being on our panel. I'm going to stop this screen sharing now and get you guys in focus. And so the way this is going to work today for all you folks who have joined is I'm going to be asking a series of questions as we go along here of both of these folks, and one will answer, or maybe both in some cases, and we'll have some time for you folks to ask questions as well. And I would appreciate it if everyone could put their contact information into our chat so we can reach out to you again later. And also, if you have questions along the way here, feel free to put those in the chat as well. And Barbara will be monitoring that. So the first question I have for you folks is, what impact have you seen on your practice and your business during, as a result of the pandemic? What's happened?
Yeah, I'm happy to jump in and take that first. And Bob, again, thank you for the introduction. I think that, in my practice over the last year and a half, 2 years, because of the pandemic, which everyone's still kind of dealing with, a lot of folks have been kind of realizing that they need to get their affairs in order. And so our business has really picked up because people are starting to recognize that they don't want to just leave things to chance. The next day, there may be something where someone could become disabled, or God forbid, put on a ventilator, maybe even pass away. And is my family protected? I think these are the questions a lot of people are asking. And so they come to me, and when I work with a financial planner like Justin, we kind of get together and kind of solve some of those questions.
What is an estate plan anyway, and why do you need one?
Yeah, well, that's a really good question. That's a really important question to figure out from the start. What are we doing here? So, put simply, an estate plan is just the process that you go through to protect your assets if you become disabled or after you pass away. So the idea is that it allows you to kind of figure out what are the assets out there, and how do you want to transfer them? Who do you want to transfer them? Your family, loved ones, charities. You got to go through and kind of figure out who you want to provide for. And by going through the estate planning process, it allows you to name individuals who you want to help you if you become disabled, or after you pass away. And then, of course, there's the practical side to it, because it helps save on time, kind of administering assets. It saves on fees and expenses. And in some cases, it may save even on taxes. So I know we're going to unpack a lot of that throughout this conversation for the next hour, but just put basically, that's what you're looking at.
What's the difference between a will and an estate plan?
That's another great question. And I get that a lot in my practice. I see the estate plan, like I mentioned earlier, as kind of a process. It's comprehensive and it's holistic. So you look at everything and who do you want to help you while you're alive? What are the assets you have while you're alive? Where are they supposed to go after you pass away? Who's supposed to take them, etc. A will is a narrow part of that estate planning process. It is the document that only is active after you pass away and transfers the assets where it needs to go. A will can certainly be part of an estate plan. There are will alternatives known as a trust, and we'll talk about that, I'm sure, a little later. But a will is a piece of a more comprehensive plan, and that's the estate plan.
And what's the difference in cost between just having a simple will versus having a full-blown estate plan?
Well, so what does it cost? That's another question. I obviously talk with my clients all the time about that. And I'm going to give a very lawyerly answer, which is it depends. And it depends on what your needs are and what you need the plan to do. At my firm, I do flat rate pricing. And so I'm able to price what the plan is based on the needs of individual clients. The question in my mind is kind of the same as asking, what does a house cost? And the answer is, well, where is it and how big is it? And when was the kitchen updated? And then you can kind of tell me. Same with a estate plan. What does it cost? Well, what does it do? And then you kind of figure that out. As far as a range goes, on the very low end, so to speak, I can prepare powers of attorney and a HIPAA authorization and a living will, which I know we'll talk about, for $275, and then a kind of complicated trust plan that has some charitable trust provisions can be as much as $8,000 to $10,000. So that's kind of the range, just generally, that you're looking at. But again, depending on what you need the plan to do, then I can tell you what it costs.
Okay, and that was a good lawyerly answer. Thank you. Before I get to Justin again, I'm going to ask you another question.
Sure.
So, what exactly is a medical power of attorney, and how does that work? And does making someone power of attorney mean I can't make my own medical decisions?
Well, so I guess let me back up a second and just address, there's a power of attorney, there's two types of power of attorney. There's the financial and then a medical power of attorney. The medical power of attorney is just very basically the document that allows you to name a helper when you go to the doctor. By naming an agent through the power of attorney, you as the principal give your agent the authority to talk to doctors on your behalf, to help direct your care if you need them to help coordinate hospital admissions and hospital releases. So it just allows you, or it gives you the ability to name someone to help you. To the second question, it does not make you powerless. Power of attorney does not make you powerless. It just gives someone else the ability to assist you if you are unable. And you want to get this done while you're able, because after, if you're incapacitated, it's a much more time-consuming, costly process to try and have someone to have authority on your behalf. So the medical power of attorney just basically gives you the ability to say, hey, who in my life do I trust to kind of help me take care of these things? And that person, by becoming your agent, then has to kind of follow your orders. It's a job, so they have to do what you say, which is a nice feature, I think, to make sure that you get what you need. So in fact, it doesn't make you powerless. I would say it's the opposite. It gives you, it empowers you.
Okay, thank you.
Yeah.
So back to Justin. Hopefully we have good sound now. So
try this again.
So far, so good. Financial planners like you exist to help people plan their financial future and present. So how does that actually work, and what does that cost?
Yeah, so are you able to hear me now, Bob?
Yes, yes.
All right, perfect. So really, when we're looking at a financial plan, what we would be looking into is really, it's a lot of information gathering up front. So, with you and your family, if you would like, your older adult children, we would really run through your entire financial picture. So we're looking at things like the assets that you've already acquired, some of the liabilities that you have, if any, what type of income you have, what type of expenses, and really just finding out what your goals are and what's most important to you. That's really where it, is a unique situation for each person and family that I work with, as everyone has a different goal/outcome for their life and how they want it to be. So as far as the financial plan, we would really get all of that information, and then I would come back to you with what I think is really the best strategy and what things we should start working on first. And then in addition to that, working with folks like Lewis on getting some of the legal side taken care of on that estate plan, where I do some of the estate planning from the financial side, making sure you have enough retirement income to live off of. And then if you do have more to supplement, potentially create a legacy that you can pass on to your children, or if you want to do any type of charitable giving. And so that's a quick summation of what that would look like. As far as what it would cost to do business or put together a customized and unique financial plan, it typically comes out to about 1% of the net worth that you currently have. So, as it relates to that, we're looking at everything that you have, your total net worth. And at the end of the day, it's typically right around the 1% level.
Okay, so an example would be if I have a net worth of, let's say, $500,000. So I would be paying you what, 5,000? Is that accurate?
Yes, typically in a year's period, yes.
Or in 1 year.
Yes.
And does that continue then after that on an annual basis, or how does that work?
Yep. So, we have a couple different account options and platforms over here at Edward Jones. But overall, it would be, as long as you're continuing to do business with me and we are, partnering to make sure you're accomplishing your goals, then, there is a cost of doing business there. And, in the different account platforms, we have some fee-based options. We have some typical brokerage account style options in the commission-based fee structure. But it really all depends on how you want to do business with us, and then proceeding accordingly.
So on the other side of that coin, what's the cost of not having the financial plan?
I would say much more costly, in my opinion. So, I work with a number of folks who, potentially got started a little bit later in terms of saving for their retirement. And now we're really working to make up lost ground. If you do start earlier and you take consideration into these things early on in your life, you do have the power of what's called compound interest. And that is a beautiful thing as far as if you have time on your side. If you don't have a financial plan, you're kind of like a pilot flying an airplane without a destination. So you'll certainly get somewhere, but you might end up in the wrong spot, and it might not be the best interest for you and also your family and what types of estate and legacy goals that you may have at that time.
Okay, thank you.
Absolutely.
That's a good answer. The next question is kind of for Lewis, but Justin, you'll probably want to pitch in here with this one too. What is a financial power of attorney, and how is it different than being the executor of an estate?
Well, so as I mentioned before, this is the other flavor of power of attorney. So just kind of put simply, it is the document that gives you the ability to name someone to help you with financial things. The same way medical power of attorney, go talk to doctors, or someone on your behalf can go talk to doctors. A financial power of attorney allows you to give someone the ability to go to the bank and direct your investment decisions, conduct real estate transactions. The difference between that and an executor is that a power of attorney is only active while you are alive. So it expires, it is done after you pass away, and then the person who is responsible for getting the assets where they need to go, that is the executor, but that doesn't start until you pass away. I think that as people age, it's really helpful to have a financial power of attorney in place. So, and the example I give always is, well, especially with a lot of folks moving in from, states that don't see as much snow, maybe you don't want to go drive to the bank because it's icy out. There's a lot of snow out. Maybe you want your husband or your wife or your kids to go help. By giving them the power of attorney, they can go do that. They can even go work with Justin on your financial plan if you give them that power. So it is just another document, another tool that while you're alive gives you some flexibility and allows you to get someone to help you.
Thanks.
As far as any tag along to that, I think Lewis really just nailed it. It's pretty cut and dry there. The financial power of attorney is, while you're still alive, and then as you were saying, with the will, it's afterwards, after you've passed already. So
okay. All right. Well, thank you. So kind of a related question to this power of attorney thing is, I talk to a lot of people, and a lot of folks just say, well, my oldest child is going to have my financial and maybe and medical, both powers of attorney. And what would you suggest to people to how to think about that maybe a little bit differently? Because we've all heard these situations where a person that that oldest child or somebody, maybe even somebody else, abuses that power of attorney, and maybe thinking through a little bit more about who you give it to before you give it to them. So what comments would you each have to make about that?
Sure. Yeah, I can tackle that one first, if you don't mind, Lewis.
Sure.
Yeah, so as far as that goes, when I'm working with my clients who are in their later years of life, what we do as far as within my practice is we get together with the client and then also their adult children, and we have a conversation together. And that's really it. We're really just determining, hey, mom and dad, you have 3 kids, you love them all the same, hopefully. And, now we have to determine, who is going to take over. And, from my experience, really just that, we found that it's really the people who have been more involved within their parents' lives as they've grown older. Some folks, as life goes on, some people move to different parts of the country. So, if one of the kids is still within the state, I typically see, that person being chosen just because, we can take care of matters in an easier way as opposed to potentially having to, locate someone out of state, do it digitally, that kind of thing.
Okay. Lewis?
Yeah, when I'm putting these documents together for my clients, the conversation always goes, or the question I always ask is, maybe it's the oldest kid, maybe it's the youngest kid, but who is the person in your life who do you think is capable of being responsible and responsive? They need to be able to follow your orders, and you can't have a concern about that. If they don't follow your orders, they can get in trouble. So you don't want to create a situation where they're stepping in a hole for themselves. And you obviously want your wishes to be followed. And so I understand a lot of families, the dynamic as well. The oldest is the one who's supposed to do these things. But and I can't stress this enough, when you're going through this process, or when clients are going through this process, you need to take a hard look at who is that person in the family. Maybe it could be a friend, or sometimes it's a situation where maybe the kids aren't quite where you want them to be. The power of attorney doesn't have to be a family member. There are professional firms that give those sorts of services that you can hire, and they'll do a great job. They cost more. You'd hire them, but you just have to figure out who that person is. Remember, with any of this, with the power of attorney, with the executor, these roles are jobs. They are actual jobs, and they're allowed to get paid for their time, and they're reimbursed for out-of-pocket expenses. So by naming someone the power of attorney, you're not saying, hey, gee, I love you more, or you're not saying that, and it doesn't change anybody's inheritance. Just what you're saying is, hey, while I'm alive, I need a little help, or after I pass away, you're going to be the person who's responsible for getting my assets where they need to go. I could understand if the oldest or whomever isn't the right person for all sorts of different reasons. But it's a conversation that you just have to have beforehand, so that you can figure out whether or not that's right. There's all sorts of dynamics there that you got to kind of navigate, but you just got to be honest with yourself and say, gee, who is the person who can help me? And having a conversation now about that is much better than having kids fight about it later without you there to kind of help them understand what you're thinking was.
So one of the things I'm hearing you both saying is don't let guilt get in the way of picking the right person.
Well said. Well said.
You have to do what's best for you.
Yeah. Okay. Let's talk a little bit about this thing called a living will, and why should you have one of those?
Sure, I'm happy to jump in on that. So a living will. That's also, it's a document that you put together. It's also known as an advance directive. At our office, we kind of refer to it as the pull the plug document. It is the document that covers end of life situations where after the doctors have tried to treat you, they have determined that frankly, there's no hope. And the medical technology is so good, they can just keep the machines going. They can probably keep your heart going for a long time. The quality of life may not be very good. So the doctors need to know when to turn off the life support. The nurses need to know when to take away the artificial nutrition hydration. And that's what the living will covers. It is a decision you get to make before you find yourself in that position. Once you're in that position, then it may be too late. That's why you do this thing beforehand. It covers situations where you are terminal, where there's no hope, and you cannot communicate. Remember, as the patient, right, you're always the boss. So as long as you can communicate to doctors, they'll do what you're telling them to do. But if in the absence of that, they need to know what to do, and they can get in trouble for taking off life support too soon. They don't get in trouble for keeping you on later. This is the case, and some of you on this call might remember this. This is the Terry Shivo case in Florida from about 20 years ago. She was in a persistent vegetative state. Her husband wanted them to remove life support so she could die a natural death, and her parents wanted them to keep her on life support. It was a long, drawn-out battle. I think it went up to the Florida Supreme Court maybe 2 times. So not only is it time-consuming, it's costly. Ultimately, they ended up removing her from life support, but you can avoid all that by kind of capturing your wishes now and while you're thinking clearly.
Well, just that phrase at the end, thinking correctly. So, this comes up in conversations from time to time around the word dementia. Mm-hmm. So, and people often will say to me, well, when I have really serious dementia, and I don't know who I am and I don't know who you are, I just don't want to be around anymore. Is that something that you see people putting into a living will?
Well, so a living will is a little bit separate from that. The idea with a living will is it covers situations where, but for life support, you may die a natural death. Remember, you can live with dementia for a long time. Unfortunately, my family, my grandparents, I have a little bit of experience with this. They lived a long time with dementia. It's not necessarily terminal. Now, dementia, there are terminal stages of Alzheimer's, and then the living will is the document you're looking at. But if you're not terminal, as 2 doctors in writing certify, then we're not looking at the living will.
Okay, thank you. And a question that's come in related to what we've been talking about here. So if you think you have all the right documents, is it a good idea to have them reviewed by an attorney? And what about, a lot of people are using these internet applications to create a will and so forth. So, how do you feel about that?
Personally, I feel like if people want to go through the process online to try and save some money and to simplify things, and I am happy to clean things up for them if and when something doesn't get transferred correctly. I don't think there's anything wrong with having an attorney review your documents. If it's been a while, years since you've last drafted documents, life changes, and certainly in the last 2 years, it seems like life's changing on daily. It may be worthwhile for you to make sure that your documents reflect your situation, so that you're not trying to shoehorn something in that just doesn't fit. I do see that there is a trend towards, do it yourself and online forms and that sort of thing. And, I would just say that there are reasons that, you got to pass the bar to practice law. These things are complicated. And it's just like Justin, I'm sure you deal with this with, the advent of robo advisors, having a professional in your corner to give you advice based on training and experience is invaluable. So certainly, if you want to draft things online and you think you can do it, more power to you. I think you should try. But more often than not, I find that what happens is you end up coming to an attorney because we need to clean up some of the stuff.
Yeah, and I can just make a quick point to that. Working with someone like Lewis, I think would be extremely beneficial to that, just because he will understand your situation, and he will know and unpack some things that you might not have thought about in the past, and really make sure that what your goals are, they are getting taken care of. And I think there's a huge importance on that, and knowing that the person you're working with has a good working relationship with you and does have your best interest, at heart.
So
Thank you.
one of the things I'm hearing from both of you is, I know, just kind of paraphrasing a little bit here, is one of the things that I've noticed is that human beings in general are much better at reacting than they are planning. And I know that in your work, you see this all the time. And what words of encouragement can you give to our audience and the future audience that watches this recording about the value of planning versus waiting until, hey, I wish I would have done that yesterday, but I'm going to do it. I have to do it now. So. Sure.
Yeah, so I can take a stab at that one here. As far as that goes, I think it's of the utmost importance to get this information taken care of, even at a younger age, because really what life has shown us in the past 2 years is we don't know what it's going to throw at us. And I don't think any one of us could have really expected a global pandemic to happen and then continue to be happening currently. So just having that taken care of while you're, again, thinking correctly and in good health is really paramount to making sure that what your wishes are and your desires are for the future are being taken care of. On the flip side there, from the financial side, really just getting going in general on working towards your goals, your retirement goals, your legacy and estate goals. Doing so earlier allows you to have more time to get to where you want to be, as opposed to, if you started to look into it in your later years of life, you may not be able to actually bring those goals to fruition.
Okay.
Yeah, so just piggybacking off that, the way I kind of like to think about it is the difference between going to the dentist for a routine tooth cleaning and going to the dentist for a root canal. Which one is more pleasant? And neither of them are anybody's favorite. I don't mind going to the dentist, but I certainly, it's not my favorite thing. But by doing routine cleaning, I maintain better dental health. A root canal is painful and expensive and time consuming and even more unpleasant. So if you do planning, that's that routine maintenance that makes sure that things are sticking the way they should be. I can understand that people don't totally want to think about these things. Some of these things aren't pleasant to kind of think about, gee, what happens if I'm disabled? Or, oh, gee, what happens to my kids if I'm not around? That's nobody's favorite conversation. But in the event, if it were to happen, the conversation would happen again. You don't get any say in it. And it's much more painful. By doing planning, you get a semblance of, you get a lot of control, you get some predictability, and you get a peace of mind knowing that these things are taken care of. You don't have to think about it every day. So you're welcome to, and I'm happy to talk with you. But, all you've got to do is kind of once every year, once every 3 years, once every 5 years, kind of take stock of things and say, gee, our life, how has it evolved? How's my life evolved? And do I have the documents that, are the documents that I have still reflective of my wishes? That's where that's at.
Okay, and speaking of documents, kind of getting back to the will and estate plan thing, I've heard, we've all heard just these terrible things about going through probate. It's a long, drawn out, expensive process. And is it really? I mean, what happens when an estate goes into probate? How does that
Yeah,
work?
yeah, that's a great question. And Justin, if you don't mind, I'll take at least the first stab at this one. Probate is nothing to be afraid of, first and foremost. I do a lot of probate work in my practice, and it is something that you go through. I do a lot of probate work in my practice. It is fundamentally, it's just the process by which you transfer your assets after you pass away if you have a will. You bring the will to the court. The court gives somebody authority to act on your behalf, and that person, known as the executor, we mentioned that a little earlier, that person just transfers the assets according to the terms of the will. There's not a whole lot of, oh, gee, now that mom and dad are dead, I'm reading the will. I think I need a little bit more. That's not probate. The entire plot process can last, anywhere from about 6 to 18 months. And that really depends on how complex your estate is, what kind of assets there are, and whether or not there are any disputes between your beneficiaries, between people who are inheriting your property. One thing about probate, just so you know, it is a public process. So what I mean by that is you bring your will and you have to, or you should file it with the court. So with the court filing, this is a publicly available document, and people can see the details of your estate, what your assets are, and who stands to receive it. I do a lot of probate work. Like I said, it's not a bad thing, but I want to be kind of clear about this. You can avoid probate if you want. There are ways to transfer assets without going to probate. It kind of depends on what the asset is. And I would work with a financial planner like Justin to make sure things like beneficiary designation forms are filled out if it's a retirement account or an investment account. But word of caution, I don't think you want to be totally doing this yourself, because depending on the asset, you may accidentally trigger, tax consequences if the asset transfers the wrong way, or maybe you don't want the asset to go to outright into someone's pocket. You want to put little strings on it. So I don't think you should immediately log off off this presentation and start filling out that stuff. But I would work with a financial advisor like Justin to make sure that those things are taken care of. And that's one way to avoid probate. That would be a part of the estate planning process, which is, do you want to avoid probate? Nothing wrong with it, but if you're a little bit more private, if you want, if you want an efficient transfer of assets, I mentioned the process can take anywhere from 6 to 18 months. There are ways to avoid probate where the assets transfer to the people you want it to transfer to a little sooner. So it just kind of depends on what your goals are. So I don't think probate's that bad. I think it gets a bad rap, I gotta say, but certainly avoidable and worth talking about with an attorney.
You're muted, Bob.
Sorry. This has come up recently, in my life, talking to some friends. A will gets lost. What happens then?
Well, I would hope that there's a digital copy floating around. And if you do have a copy, you can hire an attorney and they can kind of take that copy and go through a process known as proving it up, proving the will and making sure that it's a valid, a valid copy, that something hasn't been changed. In most cases, in all cases, an original is preferable, but it doesn't completely negate it. So it just kind of depends. If the original isn't available, what is available, and what are the consequences of that? So always, an original is preferred. oftentimes, just one more point, I guess. I'm thinking when we go through our planning process, obviously I want to make sure, hey, gee, can you find the will? A son or a daughter comes to me and says, Mom or Dad died. And one of the top questions I have is, can you find the will? That's priority. That's high up there.
And if there are no copies and the will is lost, what happens then?
Well, then we have to proceed as if you don't have a will, which is known as an intestate probate. That's the legal term for it. And then your assets will transfer based on the laws according to the state that you die in. In Colorado, first it goes to a surviving spouse, and I'm speaking just kind of generally. It goes to your surviving spouse, to kids, to parents. It goes to your legal heirs. But the state has laws. The state kind of provides a default for you in the event that there is no will, which is why estate planning is so important, because the state provides where your assets are going to go, and that may not be where you want it to go. And so it's so critical to go through this process just so you have some control and some peace of mind over where your assets are going.
Well, another thing we often hear about with, and part of an estate plan would be trusts. And so a trust, the trust we hear most about are from really, really wealthy people, and maybe they set up some kind of a charitable trust or, any kind of trust. And so if my most valuable asset, is my home, do I need a trust?
Well, so a trust is, I should say a charitable trust is one flavor of a trust. There is no minimum amount of assets that you have to have in order for a trust to be appropriate for you. Trusts are kind of the modern trend in estate planning. It's an alternative to using a will. It is more efficient. It helps transfer the assets without going through probate. There's privacy. So nobody can look under the hood of a trust and see, oh, gee, kid A gets X amount and B gets Y amount, the same way you kind of have through the probate process. With a trust, you can get a little bit of asset protection for your heirs, for your beneficiaries. And in some cases, you can use trust to help save on taxes if your situation calls for it. If in the situation that you described specifically, gee, my only asset is, my most important asset is a house, a trust may not be right for you. And that would be a conversation that we talk about. We would actually use a different mechanism to actually help transfer that asset and avoid probate, and that's known as a beneficiary deed. And I'm happy to talk more about that, but to your point about trust, certainly I have clients who are, I think, pretty successful, who have will-based plans, and that's totally fine. And I have clients who may not have millions and millions of dollars, but for other reasons, we put a trust in place for them and for their loved ones. You don't want to, the amount of assets is not really what drives the plan design. What drives the plan design is your goals and your priorities.
Okay, thank you. That's kind of the end of my prepared questions. Now we have one here from Flo in the chat for Lewis. Lewis.
Yeah, I'm just reading it right now. So the question that Flo asked is, I had an attorney advise that setting up a trust didn't make sense unless there was more than $500,000 in real assets involved. I think that's a little bit of a rigid rule of thumb. I would have a few follow-up questions with that attorney. Again, as far as our process is concerned, I would always try to figure out what the client's needs are, what the client's goals are, and then say, hey, here's how it would work if we did a trust-based plan, and here's how it would work with a will-based plan, and here are the consequences of going and using that. And if you have $500,000 or $5 million, that's not as important. Again, I think sometimes just because of the way trusts are talked about in popular culture, people kind of tie it to the assets. Trust fund kids are kind of a thing, and it's just, I think that's kind of inaccurate. I think you're just trying to figure out what are your goals, and an attorney is there to advise you. Does a trust make sense for your goals? Does a will make sense for your goals? Ultimately, you're the boss, so you can lay that out for someone, and the client gets to choose. With a trust, and I guess since we're kind of talking about it, with a trust, you have to front load the work, and this is one of the ways you avoid probate. You front load the work, and you make sure that the assets actually go into the trust either while you're alive, you can retitle the assets, or upon your death, filling out beneficiary designation forms, or just funding the trust. That is what that's kind of the process known as funding the trust. So you kind of have to spend a little bit of time and energy on the front end while you're alive, making sure the trust works. But then if you're disabled or when you pass away, then your assets are efficiently transferred. With a will, you don't have to do anything while you're alive. A will isn't active until after you pass away. But at the time you pass away, you would then hire an attorney to go through the probate process. Trusts cost more than wills because trusts do more than wills. Practically speaking, even though their wills may be, a will-based estate plan, generally speaking, is going to be less expensive than a trust-based estate plan. But because the probate element of wills, it kind of all comes out in the wash. So it's not much different, but a trust can save you on time and money, at least over the course of it. It's certainly more efficient than a will. Again, this conversation is really just depends on what are your goals, what are your priorities, what are we trying to accomplish, and the trust can certainly be a tool that accomplishes those.
All right, thanks, Louis. Justin, do you have anything you'd like to add to that?
I think overall, Louis covered it. It's really what you and your family want to have happen. What is your unique goal and situation? So I think Louis nailed it on the head.
And Justin, I guess I have a question for you. Have you worked with a lot of families where there is a trustee who's helping mom and dad with kind of manage their trust if they're disabled, or administer the trust after they pass away?
Yeah, so my experience with that hasn't been, I guess, too expansive. We do have a couple trusts set up among a couple of my clients, but as far as, taking that next step, we haven't gotten there because, they're still in really good health and things are going well. So from my experience thus far, I haven't had a lot of that situation, those situations arise, at least in my practice here.
So what comments would you have about the people that have small children? They're under the age of 18, and what's your advice to them about setting something up for who's going to take care of those kids if something happens to them?
Well, so there's two pieces to that question. And if you are under 18 in the state of Colorado and across the country, you're actually under a legal disability. You're a minor. And so somebody needs to take care of you and make sure you're going to school and clothed and fed, and someone has to legally manage your money. If you have nothing in place, then your family will go through a court proceeding. You'll have to hire an attorney, and you might get the person who's going to look after your kids, but it's not guaranteed. If you do planning now, you can name, and God forbid this happens, but if something were to happen where you're no longer able to care for the kids, you can name a guardian, and the guardian is the person who makes sure your kids are getting to school on time, getting good grades, make sure they're clothed and fed, that sort of thing. You can name a guardian beforehand, and they kind of care after your kids. And then you can also name someone who will manage your children's money, whatever their inheritance is. Kind of a corollary to that, and Justin, I'm sure you talk with your clients about this a lot, is okay, you're having someone manage a child's money, but if they turn 18 or 21, once they become age majority, they receive their money in their pocket. And the question we ask ourselves is that right? Do you want an 18-year-old? Do you want an 18-year-old managing an inheritance? I remember what I was like when I was 18. I think that would have been a lot to do and a lot to manage. So one of the questions through my estate planning process that I always ask clients is, what age? It's a little academic because parents are going to live a long time and they're going to see their kids go through high school and college and mature and prosper. But if something were to happen, what is the right age to receive an inheritance? And in my practice, the youngest a lot of times starts at 25, but I have people say, well, I don't want my kids to get anything until they're 35, 40. So that's kind of a little bit separate from the guardian, but it's important because the person who's the guardian there also has to be someone who's managing the money. And that's the trustee. And then while they're managing the money, you have to decide, when do they manage the money forever? And when do the kids receive the money? There's all sorts of variations on this theme, but if you don't name someone, the default is a long, time-consuming, potentially expensive, certainly traumatic experience, or can be anyways, where the kids are going to court and there's hearings and a judge appoints someone, and maybe it's the right person, maybe it's not. That's scary. I think any family would be reasonably want to say, gee, we could avoid that. And there is certainly a way to do that.
Okay, thank you for that. I would like to open this up for the audience. If you have questions of either Lewis or Justin or both, go ahead and unmute yourself and ask. Or if you have other comments that you'd like to make. No?
Well, hearing none, I do have one comment, and this just comes up pretty often, so I thought I'd address it. And Justin, I got to imagine you get this fairly often. Death taxes. A lot of people are worried, oh, gee, is the government going to come after me? I've been successful. I've paid my taxes while I'm alive, and the market's good, a lot of appreciation. Am I going to have to pay taxes? Or I should say, are my heirs going to have to pay taxes? And I guess the first thing I would say is most of the, generally speaking, death taxes are avoidable. And you would talk with, a financial professional like Justin, you talk with me, we work with a CPA to figure out, okay, what are the taxes look like? And then there are all sorts of strategies we can do to avoid them. Right now, this year, I'm laughing because the first $12 million that you own individually, or $24 million as a married couple, passes to your beneficiaries tax-free. I'm laughing because that's a lot of money. You can be very financially comfortable and not have a tax bill. However, with that said, the Congress is that tax rate is going to change as of January 1st, 2026. So that's about 3-4 years from now. Congress could act to change that before then, but if they do nothing, then it sunsets and goes back to, I think, 5 or 6 million, Justin, you may know. So I guess, along those lines, I would ask that, if you talk to an attorney, for right now, most people don't have a taxable estate. Most people don't have $12 million or $24 million. If you do, good work. That's a good problem to have. We can solve it for you, certainly. Most people, it doesn't apply, but that may be subject to change. Another question that a lot of people ask me is, and Justin, I'm sure for you too, especially for investments, is, do I got to pay capital gains tax on, investments that have appreciated? I inherited an IRA. And a lot of assets, actually, you get to inherit them at a stepped up basis, meaning you don't have to pay the appreciation from when mom or dad bought the asset. And actually, Justin, if you would actually talk a little bit more about that, as far as investments go, I'll defer to you. What's the strategy there?
Yeah, absolutely. So as far as that step up cost basis goes, I actually have a direct scenario. One of my clients, among my wealthiest clients, he was actually given an inheritance of around $6 million from his uncle. And what had happened was his uncle had gotten into 2 different stock investments when they were just coming out as companies. And he put a lot of money into 2 different companies at lower share prices. And then over his lifetime, those companies really grew. They're some of the biggest companies that we currently know today in the US here. And so with that stepped up cost basis, he was actually able to transfer over his roughly 6 million without having to pay that capital gains consequence taxes because of having that set up prior to his uncle passing, having the inheritance all sound and secure prior to that happening, which is huge. That would have been an incredibly large tax bill.
So yeah. I guess the one thing
$1 million. That would have been what, almost $2 million in taxes.
Right, significant, you might say.
So, one thing I'd say, just to add to this, sorry to interrupt, Bob, one thing I would say is, it kind of also depends on what the asset is. Normally, generally speaking, the only asset that I'm aware of, and Justin, you may have some insight into this, the only asset that I'm aware of that passes tax, that has an unavoidable tax, so you have to pay the tax, would be an income tax, kind of a deferred retirement account. But otherwise, you get the step up in basis if you inherit something, which, as Justin just kind of illustrated, is pretty powerful. It's pretty good stuff.
Yeah, huge.
Yeah, well, we need better uncles. I can see that already.
Yeah, I could use one of those too.
Okay. All right, folks. Are there any other questions or comments from our audience today? And if not, I think we can wrap this up. Justin, do you have any closing comments you wanted to make, and Lewis?
Yeah, I really appreciate Bob and Barbara and AgeWise for putting this together. I think this type of thing is extremely important. Not just now, but with everything going on in the future here, this kind of stuff I believe will start taking higher precedence for a lot of people, and I believe it should. Other than that, I'm happy to chat with anyone that wants to talk about some of these different things as it relates to the financial and estate planning side of things. I don't charge anything to chat with folks, and they come with no obligations. I'm really in this industry to help as many people as I can, and that's really what helps me get out of bed. So I appreciate you all, and I'll end it with that. Thanks, Bob.
Thank you, Justin. Lewis.
Yeah, so I would second that. Thank you, Bob, Barbara. Thank you, AgeWise, for putting this on, having me as a panelist. I enjoyed our conversation. I would be happy to chat with anyone free of charge if they have any questions. That would be really good. I think we just touched on a lot of basics here, just skimmed the surface, and there's a lot more. We could go on for another hour, 2 hours, I'm sure. But there's all sorts of things we can discuss. So please, if you have questions, don't hesitate to reach out to me. I'd be happy to have a conversation and assist, and make sure that you can get taken care of. That's kind of the goal here.
All right, thank you. And I've just put Lewis and Justin's contact info into the chat, so you can see that. And for anyone who would like to save the chat, I always want to remind people how to do that. You click on those 3 little dots in the upper right-hand corner, and then you can just click Save Chat, and then you'll have it on your computer as well.
Hey, Bob, I'm not seeing the contact information in the chat. Did I miss that?
Didn't I do it? Okay, well, maybe I. All right, let me try it again. There you go.
There we go. There we go.
I didn't hit the enter button. That was kind of important. but there it is. So, okay. Well, thank you all for joining us today, and we much appreciate you being here. And thanks to Lewis and Justin for giving us a lot of great information. So have a great afternoon, everyone. Take care.